Hi, good evening. I call this meeting to order. Thank you for joining us. First up, we'll have our roll call. So Dylan, if you'd like to do that, please.
Bernal,
Here.
Elliot Pahinui, Melendres, Ochiro. Here. Smith,
Here.
Verre,
Here.
Yoninaka.
Here.
All right, Chair, we have quorum.
Thank you. I will let you know that Kathleen Panui reached out to me and she had some board business, so she will not be able to make it this evening. Thank you. With that said, we can move on to our first order of business, and that is the approval of the committee minutes from our last meeting. Does anyone have any corrections they wish to offer at this juncture? Seeing none, we will adopt as distributed. Thank you very much. So then we can get into our new business, which includes our consideration of our modified proposal. Everybody, if you went on the shared drive for this month for the committee, this is version 2507.14. There was another version earlier, which was 2507.04, something like that. So just make sure you have the latest version, which is 14. Thank you. So with that said, if we go down to number A1, which is our review of the edits, if you look through, there's just a number of items like the business working days. And I just highlighted everything so everyone could plainly see. The stuff in yellow is added. So we will talk about that throughout our meeting. But the blue and the reds are all edits from before, except if they're in the yellow. Are there any questions about that? Kevin Lott, please, sir.
Chair, thank you. I just wanted to note that I did have some difficulty clicking through the link that was in the meeting agenda to find a folder that would contain the document to which you're referring now. And I don't know if there's an alternative place to find it because I don't see a folder for Neighborhood Plan Committee 2025 that represents this month. And the most recent file is from, looks like April. But if in the chat, if you could have someone post an actual URL to reach the file that'll be discussion, that'd be helpful, if possible. Thank you.
You're welcome. I think one of the issues is if we send out a URL from that particular folder, then you can't go back down the tree, essentially the folder tree. So that's why everything starts out of the commission. Then you go to the committees. Then you obviously select neighborhood plan, the year, and then for under that, it's each month. So that you should be able to find it. And Dylan is kind of going through it right now.
Yeah, thank you, Chair. I just want to reflect that in doing that process, there are 3 subfolders in the 2025 year folder for January, February, and April. I just didn't see anything that was more recent than that.
Well, I actually created this, I think, at the end of June. And so I posted some files. I have updated it since. So that 07-2025 it's been there. That's because I've been uploading stuff to it. So sorry if you weren't able to find it, but
Dropping it in now.
okay.
There were problems with the website yesterday.
I know maybe there is but this is Google. If you have the link to the Google Drive, so you should be able.
Again, just to be clear, this was following the URL that's in the meeting agenda at the top, where I think it refers to meeting documents, or meeting materials, rather.
Okay,
So,
well, we're
again,
looking
just
that
wanted to
up, but okay.
Thank you.
I thought I followed up on you. You had a question before I followed, but maybe not. Okay, thank you. So I hope you can get it because that's what we're going to be working on is this July 14th version. So anyway, with that said, are there any other comments about the past edits? Okay, hearing none. We
No.
can move on. Okay, thank you. Hearing none, we'll move on to our first actual provision, and that is an edit of 101D2. And let me make sure that that's I've looked at this so many times, I forget what's new and what's not.
You said the yellow.
I said the yellow, so
So that's what
I
page
think
one.
it was a change. Okay, so I'm not sure there's. I think what happened is that is not, yellow came in, I'm sorry, the yellow highlights were items that came in after the agenda deadline. I apologize, that's what it is. So some of these blues and strikeouts actually do pertain. They're not just from the last meeting edits. I apologize for that. But yeah, so number 2 is, I think was based on some comments. There was an addition of the time length. And we just wanted to make it clear that it would go back and kind of recircle through that review process with the executive secretary and the board and the commission chair. So does anyone have any comments on that section or issues? And Kevin, your hand has been up. Did you mean to put it down or do you have a question?
My apologies, Chair, but I just wanted to clarify again, the URL that's been posted, I just don't know that that folder can be reached through the URL that's in the meeting agenda. I'm just trying to click through to find it out, but thank you.
Okay, well, we'll follow up with the meeting agenda and make sure it's correct, for future reference. Thank you. So hearing no comments on that issue, we can go down to, okay, well, it tells you right here. I'm sorry, I didn't read the agenda. It says, so he just allows the complaint not to alter the original complaint, and then it adds the 10-day period for submission, because we didn't have, I think, the submission deadline, and there needs to be one. Okay, so without any questions, we can go to 101E.
We have your hand from Greg.
Greg Masakian, please go ahead.
Thank you. Aloha.
Aloha.
So a question, it is confusing when you do look at the edits and things, you're seeing things that are changed, but you don't always see what was changed. So that is something when you go back and forth on some of these documents. I'm not going to say they're all like that, but it's confusing to me when I review. I'm concerned with the 10-day, because you just mentioned 10-day. I know I've brought this up before, but it used to be 45 days. Is that correct for filing a complaint?
Yes.
Okay. And here's a thought that I had while I was looking at that again and saying that that's nowhere near enough time to be able to submit a complaint. So here's a scenario. If you don't go to the meeting, but you watch a meeting, which is then posted either through, through Alelo or through the Neighborhood Commission website, and depending on how many.
Greg, I'm sorry. Can you hold that when we talk? Because I think you're talking about just filing a complaint. We're going to do an overview of the whole process, and I'll come back about that. I meant this. So this is specific for right at this point in time. 101 D2, or now we're on E. So yeah, when you go for the submission, there is going to be a point in this meeting, assuming we get to it, which we should, that you have a chance to.
Okay, that's fine. I'll bring it up.
Thank you. Yeah, and if I forget to call on you, I'll call on you first if I recall. Okay, so item E, which I think. Okay, that's just moving around items, so there's no change.
No change.
If you look at G2,
F.
that was, you had to have a name for the person kind of managing the meeting. So I called it the facilitator. That just kind of something I arbitrarily came up with. If anyone has a better idea or wants to change that, please go ahead and make a suggestion. But that's so I just added that so that we could designate the person who had to submit the report. Without any comment, if you look at G2 again, deleted the respondents, response language, just redundant. Yeah, there was actually additional language in here and it just wasn't needed because it was already covered. So it's just deleted. So if we go down to G3, that there was an addition of a deadline for the submission of the report, because we had talked about when the facilitator had to submit the report. So there are any questions about that? So that's a 10 business day also. So G3, again, we have added an allowance for the respondent to submit objections, because we initially only had it for the complainant, but then, kind of struck me that the respondent might not like what the facilitator has to say either. So it gives them an opportunity to add something before it goes to the commission. So without that, it was kind of like they weren't really supposed to add anything. So, and that would be really unfair. So that's why that was added. Are there any questions thus far? We're making good progress.
Patrick,
Yes, sir.
just one, and I'm sorry to take you back for just a minute. On page 2, that first section, D1, so 218-101, D1, as I look at the sub 1 and sub 2, is the last word, should the last word of those 2 lines be complaint? Because it refers to within 10 business days after filing of the filing in both instances.
Oh, filing of the complaint. Thank you.
So at least for the moment, okay,
Yeah, I think that was a mistake. So thank you very much
okay,
for catching that.
thank you. That one just hit my eye, so.
Oh, no, I don't know. I'm not sure why we missed that. I guess it was just, we thought the words were there. So Kevin, go ahead, please.
Chair, thank you. I was back down to, I believe, the new G3 and then sub 3, which you mentioned about the permission of a respondent to submit an objection. I think that's great. One flaw that we saw in the current neighborhood plan was that those types of responses could be submitted, but the commission itself or the convening committee could choose not to read those submissions. Is there language that will provide for that deeper within the document?
No, I don't think there is language that requires the commission to review all the submitted material, be it testimony or whatever, but I would hope that the commission would do that. I think that would be a lapse, me personally, but that would be difficult to kind of put to legislate that they must actually review each item. But I think they would be derelict if they didn't.
Well, that's how I
So-
felt when it happened to me. But I mean, of course, the current language says that the committee or the commission rather shall review these types of submissions before making a final pronouncement, if you will. Again, I'm just wondering if that is a sense that wants to be retained in the new version of the complaint process.
Do you know, well, I have the old provision somewhere, but do you know what provision that is? Can you cite it?
I can pull it up as close to 218-103D10 sub 3, I think. That's off the top of my head.
Okay. Okay, well, let me, why don't we consider that, again, just like I'll take you after Greg when we get to the overall, and that can be an issue you can bring up at that point, okay?
Thank you.
Thank you. So are there any questions or concerns through item G on the agenda? So next up, we have item H. And one of the issues is there was really no subsection regarding mediation. So we had no guidance. And so this just puts some parameters there. It does not give a deadline for the mediator to submit anything, because the mediator is very likely outside the control of the boards or the commission. So hopefully they would be professional, and that would be part of selecting a mediator. I guess if the mediator was delaying, then we wouldn't do it in the future. But it does require that within 10 days of when the report is distributed to the parties, that the parties file their objections. So are there any questions or concerns?
Good question.
Yes, sir.
For mediation,
why would the complainant or respondent submit a rebuttal? Because don't the parties have to agree to whatever is agreed to in a mediation?
I
It's not
think,
like a decision that they're making. It's a mutual agreement by the parties, the complainant and the respondent. So why would they be submitting a rebuttal if they already agreed to what's contained in the agreement?
it's my understanding mediation doesn't always have to meet with agreements.
Correct.
It's
They
a
can
failed,
fail.
it's a failed mediation. And so it's
There is
basically, yeah, it's basically the same process as we have for meeting with the board chair or the vice chair or that type of thing, or a neutral third party. That facilitator, in this case, a mediator, would produce a report and both parties, one or either parties might not like it. So it is a failed mediation. And then that would go to the commission for a review.
I thought that the mediator doesn't make decisions. They have to try to get the parties to reach an agreement. If
Right.
they don't reach an agreement, that's it. They're done.
Mhm.
It's failed. So they don't issue a decision as to what the parties gotta do, as I understand the mediation process.
I sometimes in a court setting they do, but
Yeah,
I'm
but
not.
this is not a court setting. This is like a
Yeah.
voluntary agreement to go to mediation, see if the parties can reach some kind of amicable resolution to the problem that they have. So it's not like you know, a very formal process. It's, you can handwrite the agreement at the mediation, for example, and say, we agree to the following, you know?
I don't, I really don't know how the mediation would work in this sense.
Well, as I understand the mediation, like the way they do the voluntary ones with
Okay.
the justice, mediation center. The parties have to agree, if they're gonna agree to anything, the two parties have to agree. If they don't agree, done. There's no agreement. So the mediator doesn't decide for the parties what the outcome should be. They just try to get the parties to reach a point where they can reach an agreement. And that's it. That's all they try to do is facilitate agreement, an agreement. It's not like an arbitrator. For an arbitrator,
Well, that's.
you have it's a different process. They come up with a, decision. The parties may like it or not, but they will issue a decision. But in the case of a mediation, you just try to see if that process will work to get the parties to reach some kind of agreement.
So where do we have the roles and responsibilities of mediator, so that all the mediators that?
We don't have that.
volunteer-
We don't have
We don't have
that,
that.
and that's getting, if we start doing that, we're really gonna get detailed.
Right.
We have to even look at the current plan. There's a lot unsaid in the current plan. And so I would say it probably would be a mistake to try to get too much and say they've got to do X, Y, and Z.
Because the current plan does not have anything about mediation.
Well, but I'm saying even in other parts of the process, it doesn't always specify everything.
Yeah, but if you have a mediation, then you have to have something to explain what that process will be, I think.
Well, and I thought this was sufficient. So what could we say? Something like if the mediator produces a report.
No, that's the other thing is that, as I understand it, the mediators in a voluntary process don't even prepare a report.
Well, that's why I said if, but I wasn't aware of
Because
that.
they don't get paid, so, they're not gonna go write a decision.
No, but it should be documented outcome.
Yeah, I
Not
thought,
necessarily,
I thought they would have.
because if
at
they
least-
fail to reach agreement, there's no,
Well, that's,
they throw away their notes.
Yeah, but, well, okay, I wasn't.
Literally.
So what's the upshot here? Do you think we should just, take away that response to a report language because there won't be a report?
Well, that's the thing, is that unless we flesh out what the mediation will entail, then you cannot just say that this is what's going to happen.
Well, but
Because like I said, that my understanding of a mediation is that, the parties don't reach some kind of agreement. That's it, it ends, they're done. There's no report of any findings.
well, we don't really know, okay, Tom, would you like to comment?
Thank you, Chair. Quick comment is the mediator, I think this is where there's a little bit of confusion. and I appreciate your comments, Richard, distinguishing between a mediator and an arbitrator. The language here, I'm on page 3, last subsection H.
Right.
Third sentence, where it makes reference to quote unquote, the findings for a review. I think different language to simply state the results of the meeting or the mediation as compared to findings. Because as Richard just said, it's a matter of, first of all, you guys willing to sit down? Okay, can we come to some agreement here between you? Because a mediator is not serving in the role of the NCO, et cetera. So it's not really a report of the finding, you know, we have problems by this board member or whatever. It's just, it came to mediation based on the disagreement, whatever the problem was between these two individuals, for instance. And either they could not come to a mutual agreement. And so this comes back to the executive secretary or the commission, you know, or whatever, or the parties did reach a mutual decision to 1, 2, 3, I mean, whatever it is. Because I can well foresee something where, okay, I sat down for that. I only was willing to go to one meeting, but my report to my board or to the executive secretary or a member of the commission is whatever, which is distinctly not what was agreed to or differs from, that's not my recollection at all, right? So you may still have a disagreement as to what was actually agreed to, right? So the mediation is purely, did the two parties, the complainant and the respondent, kind of resolve something that way as compared to findings of the mediator. So that's the only language that I'm focusing on, is simply a report from the mediator as to the results of the mediation. Not findings, that puts it in a different position.
The commission wouldn't need to review the, if it's just an agreement, the complaint would be concluded at that point. So I don't think there's any reason for the commission to review that.
So that's simply reporting on the result.
Well, I mean, I don't even think that's necessary. I think with all the complaints, there would be some final report given, but it would just be like, this was sent to mediation. The parties agreed and that was it. So I don't know that we need to write that the executive secretary is required to make that report. I think it, because people will ask, it's like, what happened to this? Like if you have complaint, you know, 30, complaint 32, they're going to say, what happened to complaint 31? And so that's what I'm saying. I don't know there's necessarily
Well,
linkage.
the intent here, from my perspective, is very simply, Richard, you're serving as a mediator, you did whatever, you met with the parties, all this other kind of stuff. And in essence, what you're simply reporting back is, in fact, the meeting was held, the parties either did or did not come to a conclusion.
Okay, so,
So it's simply reporting back and sort of putting a period there.
so there would be no need, and let me just clarify this, no need for the parties to add any additional material after mediation.
Well, I can foresee in mediation, say the parties are talking about problems they've had with the chair or, you know, getting things posted on the agenda. I mean, they could say we're gonna reach an agreement, and their agreement could be in conflict with the neighborhood plan, for example. We don't know that, but it could. And in that case, if they agree to something that may be in violation of the neighborhood plan in some way, then they couldn't implement it, right? Period. I mean, they can't, if it's in violation, they can't. They may try, but they'll be in violation of the plan. In that instance, I can see that being a problem. Hopefully that doesn't happen if it goes to mediation, but actually, you don't even need a report for the mediator to meet. The parties can tell you if they reach an agreement or not.
True. And that's because the whole point is, to me, you need a conclusion.
Right.
So that the NCO can check that complaint off
Right.
as being, that process is completed. whatever the final result was.
Wouldn't the mediator provide the results of that mediation to the commission for acceptance? Because they could agree to something that the commission may say, no, you can't. do
But they
that."
don't produce a report. I don't know.
But no, but they should produce the results of the mediation, which is a report,
Yeah.
that this is
Maybe
what.
they don't
this is
typically
what-
distribute the report, but
Typically, they don't. I mean, in a voluntary case,
Not even a
They-
one-liner
they-
that says we did not
no,
find a
they
complaint.
don't produce a report. The only written document you may have is coming out of the mediation is where the parties say, write up an agreement, we agree to do the following. And that's it. And that's their evidence that,
That would be-
and the strength of their agreement is the goodwill of the parties to, to agree to the terms of whatever they agree to. If they don't, that's it. I mean, they're not compelled to follow the agreement if they decide they don't want to.
Okay, my concern is when they don't agree, because the problem festers and continues on. And as a commission, we should know that, this problem is probably gonna happen again.
well, if they don't agree,
They can
it
just do the
does go
complete-
back to
Yeah.
the commission, but we have to have some mechanism to, at least the mediator calls and say, okay, this has
Yeah.
been resolved or has not been resolved. Maybe we call that the report, they're reporting whether it worked or not. Either it did or it didn't. And the question becomes, because we don't define a report like it has to be some written report. It
Yeah,
could be just a report, they said it worked.
They did not reach agreement,
Uh,
or they did reach agreement.
and then do you allow the parties after they've been in mediation to supplement their material when it goes back to the commission? I don't see any harm there, but
Well, then you gotta maybe set forth more requirements. For example, if the parties reach an agreement, then what do they have to do? Do they have to report that to the commission for approval or not? Do they go and just say, I'm gonna be, I'm not gonna do such and such?
I don't think it's approval.
Yeah,
I
that's
think it's
what it-
us to be concerned that the issue that was raised could happen again, because there was no resolution.
no, what I mean, if there is an agreement, does the agreement have to be approved by the commission?
well, we don't know what the agreement is.
Yeah, exactly.
Yeah, so how can we approve it? Yeah, okay, go ahead.
And this is just a side comment, and this is really just related more about the implementation. I think that when we first set out on this idea for this, it was, the end goal was how do you get a couple of people in a room to talk about something, maybe in order to avoid a formal complaint in a complaint hearing process. And at some point now it has turned into talking about reports and the difference between a mediator and an arbitrator, and if a non-report means that nothing came out of it. And I feel like the plot has been lost in terms of like what the original goal was just how do you get a couple of people to sit together and just talk out something before a complaint needs to happen?
It's an alternative.
Well, it's not before the complaint happens. They certainly can do that.
Or even if the complaint does happen, just whatever, just like.
Yeah, so we're just trying to ferret out exactly. Actually, we could leave the language as is, because, we can you just don't have to interpret a report as some like lengthy diatribe of what happened. It can just be, yeah, it worked, or no, it didn't. That's a report. And then you say that the findings, they report that to the commission. So they report that to commission. Anyway, I see Greg's had his hand up. So Greg, do you want to contribute something? Go ahead, please.
Yeah, just brief. First, mediations are confidential, so you go into them with a binding agreement. So both sides go in. Typically, a mediation, the sides chat with the mediator. They're in separate rooms, but they may go all sit together and have a chat. The original intent of having the discussion is, as Robert said, is to avoid complaints. So a lot of what you guys are doing is actually making the process more complicated. But the last thing I'll add is who's paying for the mediation? Where is the funding coming for the mediation? They're not free. And there's a cost associated with that. And where are the mediators coming from? And how do you, there's a whole process behind that. and you have to be careful with that process. So there's a lot that you guys are if you're talking about things, you're making the process more difficult. And as I was saying earlier, I do think it was relevant when I was speaking about the 10 days, but I'll wait. But that was something you were talking about. That's all part of a problem with this process too. You're making it more difficult and challenge where somebody can actually challenge what you're doing by not providing enough time frame or not providing the proper format. So it's actually, I'm sitting here watching this and I'm in disbelief that you're making it much more difficult instead of easier to resolve these issues. And at the end of the day, you're just going to probably dismiss everything anyway, unless you don't like somebody. But I'll stop there. Thank you.
Thank you. Well, I would say this is an option. As far as if it's paid or whatever, if it's probably paid, we just won't utilize it. So I would imagine, because it would probably be, I don't think the parties would pay for it. I don't know if the NCO wants to be paying a mediator all the time. So I think vague is better. If we start getting too in the weeds and try to narrow everything out, specify what everything requires, then that's going to be problematic down the line, I think. But that's my opinion. Any other thoughts, Dylan?
The party conference or conference, that seemed to possibly solve the mediation without the total lapse of a third party not related to the board, but you guys do have that option with third party. And again, I think the vagueness was beneficial. So is the mediation even necessary if you have this other options?
Well, Commissioner Melendez, I hopefully he's okay with me saying anything, but he really wanted the mediation option included. That was not something I particularly was.
When you think about it, the mediation option, even if you didn't include it in the plan, parties could elect to do it on their own. if they want.
Absolutely.
So, if we took it out, we can still say, yeah, if you want to go, go.
Yeah, and then the person could withdraw the complaint. So
Perhaps.
they could do, well, I mean, they'd have to if or else the complaint would have to go some other direction. But so if this is getting really overly complicated, we could just pull it, the mediation option. I don't know that'll be utilized anyway.
I would propose to pull that.
Do have any thoughts? Mahia, do you, I see Kevin, but before I get there, Mahia, do you have any thoughts about this? Would you like to just pull the mediation language?
Yes, just pull the language. It's getting too complicated.
Okay. So Kevin, go ahead, please. Thank you, Mahia.
Thank you, Chair. If it's an unfunded mandate, and if you think back to the likelihood that two parties would agree to go to something like that as an alternative pathway for dispute resolution in this setting, I don't see it going anyplace. So I'm glad you guys struck it. Thank you.
Okay, so hearing no objection, we're gonna strike C15, which is the mediation option, and then strike this paragraph H. Okay? And I think that's the only reference, it should be the only reference to mediation in here, the ones that we just struck, so. Unless I find something else, then I think we should be good. All right, so Kevin, do you want to add something, or do you? leave your
My
hand up?
apologies. I neglected to finish before, but in striking this, is there a downstream consequence now of a complaint now more likely to get scooted out of the system overall, or is there still a pathway for having a resolution with an august body to make a ruling on things that were confusing in the eyes of the original complainant?
Okay, can you repeat that? I'm sorry, you lost me just a little bit.
Thank you, Chair. In removing this mediation process and references to it, does that make any duly filed complaint more likely to get kicked out, if you will, and not heard by the commission or some other process that's defined here? I recall earlier that it seemed like there were many pathways for a filed complaint to get kicked out. but only maybe one way for it to actually make its way through the system and actually have what we refer to now as a complaint hearing.
Okay, well, there's a difference between the hearing and review. I think you probably mean the review. The review is whether we determine whether the complaint is sufficient in whatever regard that we actually go to a hearing. So first off, the language is review. And yes, basically, almost everything has a pathway to review by the commission if the complainant so desires. I mean, so there will not be an automatic kick out because even, and I could go through each one, but if you look at that flow chart, it all comes back to the complainant always has an option and it'll always end up at the, like I said, the full commission at some point if the complainant wants to pursue it. And there's also, if you have the third, refer to a facilitator, there are certain, if the facilitator does things that I guess the respondent doesn't like, then the respondent can take it to the commission too. So, that makes sense?
Yes, thank you.
Thank you. Okay, so we've removed that language, so we can move on to, and these numbers will obviously change just a little bit. I just wanted to highlight the mailing language of 101 and in our provision, or in this version, I'll say L, because we talked about, I'm sorry, let me find the page. What page? L, okay, page 4. So it says, shall be by first class and email with email preferred. If you do both, then you can say something's preferred, but you got to do both of them anyway. So I wondered if that was really the intent or if that's something the commission wanted to change because.
I think I think we were looking at it from the standpoint of, it's kind of like with mail outs and stuff like that. Even though by law we are required to do mail, people can, if they really want, just get something by email. They don't need to receive it by physical mail.
So if it's an opt-out.
So it's almost like an opt-out. If that person agrees to say, you don't need to send me a first-class mail, I'll just take it by email, and we have that correspondence with them, then.
Yeah, the problem I see with this language is it says first-class email, first-class mail and email. So maybe if we put something.
That's true.
Yeah, I mean, I did just notice, so we'd have to have something, or if the parties so.
I'll look at the language of the
Okay.
other stuff and just.
Yeah, so let us hold off on that, but I think the intent, did everyone hear Dylan talk about the intent? And if they're okay, we'll find the language and see if we can comply with that intent. Okay?
Or you can just, instead of and, you put or email if the respondent and complainant agree.
You could.
Something like that. That's what you're saying, right?
I mean,
If they agree to be sent mailing by email, and that's what you prefer to do.
Yeah, I think the problem, I think the law does require the first class mail.
Then you can't do
So
or.
we can't really do or unless you add some language like opting out
Yeah.
or something. That's kind of the problem.
So you can't. really
Well,
opt out of
I'll
first
give you,
class mail.
well, yeah, I mean, I think the idea was just it stemmed from, like, for example, I just put up in the plan 214-111 meeting notice and agenda. And it says, our office shall maintain a list of names and addresses of persons who request notification of meetings and shall mail a copy of the notice to such persons at their last known address no later than 6 days prior to the meeting date. Use of electronic mailing is preferred.
Yeah,
So there is that stipulation requirement that we do have to send out physical mail, but if someone was really like, I'll just take it electronic.
yeah, I would say if it's adjudicatory, that may make a difference. But anyway, what would you add?
A couple of brief comments. First, what Dylan just said, I think what we need to review on that, going full of the history, exactly how you set that up. I think what we need to look at, especially with some of the recent legislative actions, is how is preference for use of electronic communication further emphasized now in sunshine law or other things. Because I would advocate for revising that language to be clear that the electronic communication is paramount, but folks may have the option of starting out, right? So I think that's something that we can, we have the opportunity to further update in that way. Second thing though is I'm getting that real uncomfortable flashback of some of our first conversations, which had to do with when we, the start for the overhaul of the neighborhood plan, in fact, were problems with the complaint process. And yet, as we got further into it, there were things with the blinders on, if you will, I would say today, that there were things in a contested case hearing situation that we then largely mirrored in the neighborhood plan. From recent conversations, the point we have made is this is the commission's process. And in that regard, at least at first review and everything else, you don't have to do this extensive contested case hearing type of model, whatever, okay? In that regard, then, first I go back to what Richard was just saying a minute ago. I would change this language to make it that, to be clear, that the manner of receiving notices or whatever in relation to a complaint, that kind of stuff or whatever, is the choice. We get the options, but is as selected by the parties, you know, whatever, okay? The other thing is that even the next, I'm looking at M2 on page 4, where it then talks about hearing notice mailings. And we fall into that same trap again, if you will, of registered or certified mail, return receipt requested. And I'm digging deep in my pocket then for how much that costs every time, right? So if we don't have to do this, and we go to, first of all, doing a selection in that regard, if you opt into this process, if you will, by filing a complaint, right? And you respond, or as compared to just disappearing or whatever, then we're going to follow up with this. In your case, it will be by mail because you don't have email or whatever. For all other parties, it will be by email. And we simply set that forward. Okay. What the ultimate may be when you finally have the proposal and it's got to be reviewed by Corp Council or whatever, I still think where we got to in the sense of this is the commission's process. It is not a contested case hearing process. If it goes to that, that can be a whole second, you know, bite at the apple, if you will. But after you try to settle this as easily as possible, because that's what we were trying to do, even with the discussion on mediation. It's how do you get this resolved as soon as possible, whatever, between the folks or the board itself or whatever, right?
Okay, well, yeah, hearing notice, we did view it as, I mean, I will say in our discussions before, we did view it as like a HRS 92 contested case hearings. And that, in that case, it did require. Now, whether, as you say, perhaps we're not required to adhere to that standard, I don't know. Okay, well, let me go to Kevin. I see he's had his hand up for a while. So Kevin, do you want to add something?
Thank you, Chair. As Mr. Heinrich noted, I'm looking at M, and in section 1, I just, for your edits, I see that's referring in sentence 2 to neighbor, board, commission. It happens to me where the hood gets dropped off the neighbor. Maybe just fix that for the next edition. But I do think the committee should recall that OIP has in fact required cancellation of individual board meetings because of lack of timely mailing of meeting materials by US mail and by email to the same individual if the recipient had requested to receive both. So you may definitely want to seek a carve out from Corp Council or OIP to make sure that if you want to have someone opt out outside of HRS requirements otherwise.
Okay, so what I propose is that we think about the language and the implications just a little bit more. And, and we take it from there. So, okay? If there's nothing further, we're just sort of tabled this until we get more information and maybe propose language. Okay? With that said, we're ready for complaints. Yeah, of options. Oh yeah, if you notice this little chart here, I mean, not chart, I'm sorry, this one document that says complaint management process up to commission review. And this really, all this is just sort of for more information. And it just tells you about all the different options that the executive secretary and the commission chair can select and how they end up essentially. So I just did that. I don't know if anybody really we don't need to go through it, but it's sort of in conjunction with the flow chart just to make sure everything works.
You're gonna strike 101C.
Yeah, and we're going to strike the mediation, which is number 5. So anyway, unless anyone has any comments, but that was just another educational tool, and I did that to make sure everything actually flowed correctly. So, okay. With that said, we're going to go to any other general questions about Chapter 18, and Greg, we were going to go back to you for I think the timetable to file complaints. So if you want to go ahead, please.
Thank you. Yeah, the time that you offer to file a complaint. So, here's a scenario. You don't attend the meeting. So there's a neighborhood board meeting that is not attended by the person that would file a complaint. They watch it online at some point. It's broadcast on Alelo at some point, and it's available online at some point. But the some point is a point in the future where you're tolling or starting a clock for that 10 days or 10 business days or whatever you want to call it. And say somebody watches a board meeting and they see there's a violation. And, say they get to it the very first day it's posted, so that's great, but maybe it's a few days later or the week of after. And so you've already lost time to file a complaint, and maybe it's after the 10 days and they see it a couple weeks later. I do believe strongly that the 10 days is not enough time to raise a concern. If you see some valid complaint, a member of the public could see something that's very serious that happens at a meeting by watching it after. And even if they see it real time, they're busy with their lives, but it's a very important complaint to file. That's not a sufficient amount of time to file. And it's absolutely not an amount of time that's sufficient to reply where somebody's very busy in their day, especially where there's false complaints filed, retaliatory, baseless ones. I had many filed against me. And those complaints need time to respond to, and 10 days is not sufficient. So I think you're going to have a real big challenge to the 10 days, but I do think it's not fair, especially from the first scenario that I gave as far as filing. I don't think it's fair, and I think that's a problem. Going from 45 days to 10, where does that come from? That's ludicrous in my opinion. So I'll stop there. I want to be really harsh on this because it's something that is very important even for legal proceedings. There's more time that's allocated, but this should be fair and equitable, and it's not the way you guys are going in this path.
Okay, well, let me respond a couple ways. First off, it's 10 business days, just so you know. It's not 10 days. Secondly, if someone does see like a board do something wrong and say they're outside the complaint window, they could call the executive secretary. I'm sure the executive will not, the secretary actually could make a complaint outside that window, but it probably won't be to a complaint, but it would be handled, because I'm sure they would reach out to the board and say, hey, you're not really supposed to be doing this, you know, it's that sort of thing. Please don't do this in the future. Right?
Yes.
You think you want to add?
Are you
No,
making me laugh now, or are you serious? Are you being
Yeah,
literal,
very-
or are you actually
No, I'm
making
very
a
serious. I mean,
Uh,
that's how
being-
I see it. It's
Okay,
all I'm
if
saying
you
is, we don't have to have a complaint for everything. If you let the NCO know that the boards aren't acting appropriately, I'm sure, I don't know, do you want to take
Well,
that?
done that, did it, done it. You guys didn't do anything. That's why there's a Hawaii Supreme Court case filed against certain parties, because
Okay,
nothing
well-
was done properly.
Okay, Lloyd, I mean, let Lloyd respond, please.
I
ahead.
was just gonna.
Or Robert,
Yeah.
or whatever.
I was just gonna say, you know, this is an example for us of sort of like letting perfect get in the way of good. And in a scenario just right now, we're having a WebEx meeting where a couple of years ago, we didn't even have that. So everyone who's tuned in online right now wouldn't even be in this meeting if they couldn't be here. And that's an example of where we've moved forward in progress. And I mean, Mr. Misakian, I'm not sure aware of your situation, but I know it would probably be a burden having to show up here every single month in person. Likewise, we also didn't have video a few years ago at every single meeting. So someone who didn't, we definitely didn't have WebEx and we didn't have video. So anyone who missed a meeting, well, you just missed a meeting and you wouldn't even know what happened at that meeting. So now what we're talking about is filing complaints for things that you saw on TV. And I don't know if that's, once again, that's trying to let perfect get in the way of good, of walking back, filing complaints for things you weren't even at, when a couple years ago, you wouldn't even seen that because you wouldn't have been able to even attend.
That makes no sense, what you just said.
Okay.
If somebody
All
does
right,
something
Kevin,
in a meeting,
I mean, not Kevin, sorry, Greg, please, hold on. Do you want to say, add anything?
Yeah, I mean, there's a number of opportunities, and because the neighborhood board system is designed for a public meeting, if someone sees something 2 weeks or 3 weeks later, that they do not agree with, they can come to the meeting and talk right in front of everyone at the meeting. And maybe the meeting, the board can decide, you know what, you're right, we shouldn't do that, or we should do something else, but bring it to the board. Tom?
Well, hold on a second. Kevin, I know you had your hand up, so please go ahead.
I almost don't want to interrupt the flow of that whole conversation, but a few things, Chair. I mean, were you suggesting that the executive secretary could in fact supplant the entire complaint process? I mean, should we put things at the feet of the executive secretary and hope that things happen? I don't think that's reasonable, as much as it would be great. But aside from that, wow. So a few things. The point that I was making earlier about if the commission would have an opportunity, if not a mandate, to review responses at the end of the complaint process. It looks to me like that is faithfully replicated in the new document. And it's a 218-103 hearings, Part D 10C, which is almost virtually the same as it was in the extant version of the neighborhood plan. So I do appreciate that. The other thing I'll note is that the question I had before about accessing the folders for this month and the last few previous months.
Well, Kevin, before you get there, I'm sorry,
Yes.
I just want to resolve if anyone had any comments on Greg's observation about the 10 business days. And Tom, so Kevin, we'll come back to that issue. Yeah, Tom, please.
Thank you, Chair. A couple of comments. First, on the days and that kind of stuff or whatever, that's always been the friction, if you will, because we are trying to resolve things quickly so that in fact they are meaningful as compared to, if I remember correctly, when I did the calculation years ago on the process that ultimately went into the plan at that point, or what we were trying to address was the minimal time period, if everything took the full time period, was something like 140 days. And obviously not meaningful, right, in quick resolution. So the days and stuff, it's always going to be a friction. Different quick comment is, if we go back right to the top of page 1, 218-101, A1, the whole point is, the executive secretary may initiate a complaint by written recommendation to the commission. Having said that, I think what is not said, and I don't know if we need to, because this is the day-to-day activities of the entirety of the NCO, and that is, a lot of things never get to the point of complaint or the formality. It's a matter of you pick up the phone or whatever, you talk to the chair, you talk to the member, whatever. It's always trying to inform and adjust the conduct and those kinds of things. So at times, I think there's been too much focus by certain individuals as to trying to have a formal complaint and therefore, pull the trigger on a very formal process, which is in most cases not calculated to satisfy anyone, okay, in that sense. The last thing to be said quickly is, I think any reference there or the encouragement, if we wanted to add a sentence or two somehow, or whatever, of in fact consulting with the executive secretary or the NCO staff or whatever, prior to filing a complaint or whatever. I mean, that's all you can do is an encouragement, but when do you stop writing, right? Because that's the ordinary conduct. You got a problem with last night's meeting, usually most folks will pick up the phone, right?
Right.
Right.
Deal with it. They got stops on that.
Oh, yeah, go ahead.
When we started looking at complaints separately, the first thing we looked at and why we did this, apart from the rest of the plan, was because of complaints that the process was just taking too long. And the first thing that we addressed was filing of complaints. And that was seen as the biggest problem in terms of, dragging these complaint processes, for a long time and delaying the whole process. So I think that was the reason why we ended up with a 10 days. So I think it's something that committee looked at the start of the process to really try to make a dent in speeding up the complaint process. And that was to change that 45 days to something much less than what it is now. So I think that's why we're at where we're at. I don't think that's going to stop filing of complaints. From what I could tell, what we've seen just in the past year, how many complaints have we had?
Well, I think the thing was that a lot of the complaints that come in are just, for example, maybe someone files something about an agenda being worded incorrectly or something not being on an agenda or something. Those are common types of, complaints. But the point is that, if a person has 45 days to file that complaint and then the respondent has 45 days to respond to that, that's 90 days, 3 months, 3 agendas later than when the incident even happened.
Okay, so I think the committee, as Richard said, the committee was very conscious about the deadlines, and we have made that decision. Greg, if you want anything more, say, and very quickly, if you could say a sentence, and I'll let you wrap it up, but we have, in light of, we did make our decision.
Yeah, it's just on a comment you made earlier about speaking up at the meetings, and at a recent meeting, now I'm not sure if it was May or June, but I know there were issues at both of those meetings. I had an OIP opinion in writing that was sent to the chair, letting him know that the permitted, well, there's a number of agenda items that weren't correct. He knew in writing before that, and it stated that the PIG was POW, and I had said that this PIG was finished. It was about a legislative PIG. I spoke up. He still allowed it to go forward, even with me holding the OIP opinion. So you had multiple board members literally violating the Sunshine Law openly at that meeting. this needs to stop, and nothing is done about it. You know,
Well,
it's been
okay,
conveyed.
Greg,
That's it. I'm
that's,
just gonna
yeah,
say.
okay, you're talking about a specific instance. We're talking process, so just so you know.
This is many of these instances. That's
Okay.
just one example, but nobody at NCO ever did anything, and all of my complaints and concerns were swept under the rug, and they were held for a year, and then all of a sudden I get 2 letters. Oh, these are all dismissed. So
Okay.
none of the process was ever followed properly by the NCO, and there was
Okay.
bias, and you know that. That's
Okay,
my
thank you.
Thank you.
Kevin, before we get to the other issue with the folder, do you have anything to add very quickly on this subject?
Yes, thank you. Regarding timing, I think before you set a 10-day rule for response, I think some data would be important. Olelo, although we have added to that or augmented it with the YouTube postings of our meetings, we should find out how long is the mean time between a recording being made at a neighbor board meeting and the time it gets posted, typically for review on Olelo, because that may be the only way that some residents who may like to attend meetings but could not for that 1 month or whatnot, they should be afforded a chance to review a meeting and have an adequate response time to contemplate, decide if it's worthy of filing a formal report, as has always been the case. And as technology advances, yes, now we have video, now we have WebEx, great, but we still need to protect the original intent of that. So that was the caution I would give.
Thank you.
Thank you.
Certainly.
Thank you. I will let you know that we did balance a number of things and we've made our decision on that. So sorry. But what was your other issue that you wanted to go back to, Kevin?
Yes, sir. Is there an opportunity tonight? Will we be discussing about the sunshine law exclusions for consideration with this complaint process?
Yes, we haven't gotten to that, and we will actually
Okay.
after we get our audience, or anybody from the public, including yourself. If you have nothing else, we can actually go to that. We have a number of 3 items to go to, so, and that's one of them.
Thank you, Chair. Then the very last thing would be that the section I mentioned before about review by the commission of objections to a hearing officer's report, the wording is still vague, although it's copied from the extant version of the plan. It just says that the commission shall review those objections, but separately that the commission shall issue its decision within 45 days. I think it's critical that that issuance of a decision comes after the review of the objections, because then it could all come after the fact, or the commission could make a snap issuance of a decision very quickly before the deadline for submission of the objections. I think that's a key loophole. I'm not sure if that's what happened in the case that I've been asking for clarification about for the past 2.5 years, but that's one thing I hope the committee would consider.
Okay, I would say maybe in that case, the commission didn't follow it. I wasn't there. If I was there, I don't recall. But it says they shall review the recommendations and all objections. I mean, it seems like if you don't do it before you make your decision, then you're not following the rules here. So I don't know whether, and if we put something else in there, if the commission's not going to follow the rules, they're not following the rules. So I hear what you're saying, but
Touché.
yeah, and I don't know what happened in that case. So, but I would hope that the commission would follow the rules like they're supposed to. So. Okay, with that said, there were a number of items that came in after the submission of the agenda that are included in here, since these were distributed to everybody online or not really distributed exactly to everybody. I think that complies with the sunshine law requirement because we didn't send it out to anybody. The first thing I want to point to is section 102. And this is the sunshine law complaints section that I think Kevin raised. And this was suggested by the NCO. And it just basically says, any complaint to failure to comply with the sunshine law, it should be directed at OIP. Now, I will tell you, there are a number of items in the plan which also are, kind of components of, or that reflect components of the sunshine law. The commission is fully entitled to be the first arbitrator there and say, this is what the plan holds. But we can't say, this is what the sunshine law holds. That's not our role, and we're specifically excluded from being able to do that. So that's why this is in here. It does ask that the filer just notify the NCO, because we would like to know, if there are any decision, or I'm sure the NCO wants to know, if anything comes up, they don't want to miss it, and that sort of thing. So with that said, I think Kevin, you were first, so go ahead, please.
Thank you, Chair. Well, I think this just raises the question for me, is this a clear carve out that the commission can or can choose not to review anything in the neighborhood plan that a complainant feels was violated that may potentially be part of or referable to OIP because it is a sunshine law issue per se, but they still may choose to make a ruling or to accept the process to start a hearing? Because if not, then we need to start mentioning on the complaint form, as there are, I believe, several specific sections that says if you include this, it's not going to count because we're not going to even talk about these things. And I raised to mind, some of the issues that have come up in the past, regarding agenda amendment, rather. I think that's something that the commission, during a complaint, could use its wisdom to decide, yes, this did, based on the evidence submitted by the complainant and perhaps by the respondent, yes, it did impact a large number of people or had a significant impact on the jurisdiction at hand. I think, isn't that what the complaint system and the commission has been for?
The commission is charged with, I'm not sure the language is right, but sort of enforcing the neighborhood plan. And if the plan says in there, like, you can't put an item on the agenda except, if it widely affects the community and requires 2/3 approval by the board, we can interpret that. We, as the commission, can interpret that. We cannot say this does or does not violate the sunshine law. So therein lies the difference. We have total control over how we interpret the plan. But if OIP comes back and they says, we could say, okay, this is fine. But OIP comes back and they said, no, it's not. You're going to have to follow OIP's decision, because they're saying, because the sunshine law obviously trumps the neighborhood plan. Sorry, that's maybe not the best choice of words, but it takes precedent or supersedes the neighborhood plan. Let's put it that way. So does that make sense? And let me go to Greg, and Kevin, I'll come back to you. But Greg, go ahead, please. How did you?
Thank you. First, OIP has stated that the NCO should be addressing sunshine law concerns. It's embedded within the neighborhood plan, as is Robert's rules. So there's sections within the neighborhood plan that explicitly talk about the sunshine law and about Robert's rules incorporated within the neighborhood plan. That said, you also have the training that all neighborhood board members are required to go through and then certify that they've taken their sunshine law training. So this is training. It's an ethics issue. So if we want to have an ethical board and a proper board, then that's part of the procedure. When the NCO decides to say, no, we don't care about the sunshine law, which is really an ethics issue, then you don't care about ethics, in my opinion. And I know others' opinions. But herein lies another problem. You've got a formal complaint process with OIP that may take a year or longer to get a response. You've got an informal process, and I know many of the attorneys over there, and I was able to get a response sometimes within a few hours of contacting them because the issue was so egregious and obvious that they could easily document it, and they did. And it stirred up a lot of controversy last year. And again, at the recent meeting that I mentioned earlier, I held up an OIP statement that was already given to the chair by email a week or two prior.
Kevin, not Kevin, I'm sorry, I keep calling Kevin. Greg, that's a specific case. We're not really talking about cases here. It's more of the procedure.
I'm not trying to give you a specific case. I'm just giving you an example of many cases. This is an example of many, many instances of sunshine law violations. So at the end of the day, when the board is ignoring the sunshine law, openly at that meeting and they're aware of it and the chair is ignoring it, blatantly ignoring it, that chair has no place on that board. And every board member that spoke violating the sunshine law, giving a report that was POW, they'd already given the report. You get one bite at that apple for the final report on a PIG. Those board members, you know, at some point they either get scolded or they get removed from the board. If you allow board members like that to be on the board, you're tainting these boards with unethical people. And that is a big concern. These are potential future politicians. And, you know, look what we have in the state. I'll leave it there. But, you know, we have a state of a lot of legislators, a bunch of them that are unethical, and some have gone to jail.
Okay. Kevin, did you want to add something?
Chair, thank you. I guess just to clarify back to my original question. So is it your intent, perhaps, I mean, at the mercy of the remainder of everybody else, but a complaint that does appear to violate something that could potentially also be an issue with sunshine law, but is clearly documented in the neighborhood plan as a violation? The complainant has a suspicion that something was violated and is asking for clarification on that. Is there a chance that the neighborhood commission would allow that complaint, duly filed, timely filed, et cetera, to go through the flow chart and reach a point where a decision could be made? Because that helps to set precedent for all neighborhood boards.
If it's in the plan, yes. But let
Okay.
me let Robert opine on this. Go ahead.
I understand what Kevin's saying, but I think where kind of the misunderstanding is that, and I don't, unfortunately, I'll just say that, I don't think we're actually going to get to a place where this is fully resolved. But the intent was, when you write bylaws, you don't copy other people's laws and put them in your own bylaws. And that's really what we're struggling with the neighborhood plan. Even right now, the sunshine law has changed to say you can have virtual meetings. There's nothing in our plan saying you can have virtual meetings. The sunshine law has changed to say you can do recorded video summary minutes. Our neighborhood plan doesn't say that you can do that. These are all things that have changed, and we would hope that would take precedent over, you know, the neighborhood plan when necessary. But the fact of the matter is that we have a hodgepodge of things that are either out of date or just sort of out of sorts in the neighborhood plan, because we're trying to copy someone else's laws and put them into a plan when those laws are not static, they change all the time. And so the intent was not to completely shirk things off. It's just that, and it even says may, but when there are instances where something is just not something that this body here feels that they can give a definitive answer on, and I don't think there are people that would want that. I think maybe if this body gave an opinion on something that's sunshine law that someone in the audience here disagreed with, well, they would probably want to hear it directly from OIP themselves. Why would they want this body to opine on laws that this body did not create? So that was really the intent. Was it doesn't mean it's always has to be that way. It was more of just one more option of, if this body does not feel that they can give that type of answer to something that is from OIP, then it could be directed that way.
Well,
Okay, no, hold on, Kevin, please. Let me ask the committee members, are we okay with including this provision? Do I hear any objections? Or do you want to discuss it more, or?
I think it's fine putting it in. Even if you didn't have it in, someone could still file a complaint with OIP as it is. This
right.
just says you can do it, but nobody needs that currently. If they want to file a complaint with OIP, and that's happened already, they can do that.
I think it's more informative. It lets people read this. Okay,
It's not a way to duck the issue.
So it's everybody, I think, all the committee members. So Kevin, hold on, Kevin. Tom, we'll brief this. Go ahead.
A couple of things. First, as to this provision and stuff, I would agree that it's useful to have there. Another quick comment is, without seeing what for some time, what the complaint form is for the NCO, perhaps what we also need to ask on that form is whether in relation to the instant complaint, whether that issue has been filed with any other agency or court as well. Because I've been in situations where, pull the trigger and it's a shotgun. Same issue, same event, et cetera.
Yeah.
The other thing, Dylan, I really appreciate what you said a moment ago, because it was part of what I was thinking, which is this. And I think I'm going to blame you. You can take responsibility if you want, but you have, I think, really changed something in my head. And if I can explain that real briefly. First, the situation often is this. Both OIP and the City and County of Honolulu Ethics Commission do not want anything to do with the neighborhood board system.
Right.
Okay, and we've talked about that in other meetings. The key on that then is, in some respects, one, if somebody wants to address it, and I'm beginning to think about it now as a result of this, is it may in fact be a charter commission issue. That's a discussion for another time, but the charter commission is now working. The other thing is, remember when we started some of this again, it was a matter that one of the original intents back in 97, 98 was to try to come up with something so that ideally I can grab this neighborhood plan and without having to go to the library and have all these other kinds of things, not to repeat it all verbatim, but rather simply have that as the operations manual, the field manual, so that the board members could see, oh, this is how the agenda needs to be done, blah, blah, blah. Okay. Where you have changed my thought pattern, and I really need to think about it a lot more, because on some things, it actually will make things easier in relation to the neighborhood plan and more difficult for the board member in the field. Sorry, that's life. And that is to try to avoid very specific repetitions of other statutes, ordinances, et cetera, particularly just by example of at least two bills that were adopted in relation to Chapter 92 this session and signed by the governor, which makes significant additions to Chapter 92. Well, how much of that are we going to have to repeat, adjust to whatever neighborhood plan? The short answer is we should address it by simply making a basic reference, one short section
Okay.
to Chapter 92, et cetera. Okay. So that would deal with a lot of different things. Unfortunately, Chair, it still doesn't address the complaint process, if you will, which is still the Kuleana of the commission and the NCO, and how do we address something like that? Thank you.
Okay, thank you. So I will say, Kevin, we've made our decision, but if you want to wrap it up about this in a sentence or two, please, you can add something.
Okay,
Sorry.
thank you. No, thank you, Chair. I think, yeah, it's a bit hodgepodge there, but I appreciate Mr. Heinrich's comments. I think the situation is still left with if the commission does hear or receives a complaint rather that may be felt to deal with HRS 92, they can dismiss it. I've asked for clarification in the past when that happens to decide why, what was the justification for dismissing, because maybe there was a misunderstanding or something to that effect. So I don't know if there's additional language that maybe needed to be added sooner or later.
Okay.
I don't think so. And then the last thing would be, is it possible to disclose what decision was rendered by Corp Counsel to permit this change within the past, say, 2 years or so, when the hearings all became this more opaque section outside of the regular meeting? They were always done in some form of an executive session in the past, yes, but there was at least some.
I think it's
record
unlikely that you're going to hear exactly what the attorney said, because that's part of attorney-client privilege. So, and I don't think the court counsel would suggest that we waive that for this case. That's my assumption. I don't know, but yeah, I don't know the answer to that, Kevin. So.
But because I asked, because is it the understanding that decisions that are made within these sections, there's no public record of, for example, ratios of votes, yay or nay against. That is completely opaque.
I don't know. That's unclear to me, but there is a standard in the law about going into executive session for these matters.
Yes.
So, yeah, I don't know the answer to that. And that's kind of beyond the scope of this discussion tonight, so. But that is, that may be an interesting question, so. For another day. Okay, so, going on, next we have suggested addition to one of our items, and that is C6, which is a notice of remediation. And Dylan, did you want to address that, or? Yep. I mean, I can kind of go through. You go ahead.
I think he has a little bit more than me.
Yeah, I was also looking at the flow chart. I think I had a question on just the labeling.
Okay, so I would let you know, so it also conjunctions with these numbers, item I. So, remediation obviously is just a remedy to fix something. And you send a receipt of the notice. And this might be one of the good things, like say the board does something they're not supposed to. And it's a procedural matter. And we just say, you need to stop and do it this other way, we consider the right way, I suppose. And that's all that is. And that just would conclude the matter.
Yeah.
And that's basically what the commission would do a lot of times anyway.
I think the basis was, why spend as Tom pointed out earlier, 45 days, all the time spent,
Yeah.
could be 140 days, whatever it is. And the end result is a letter where everyone kind of agreed to it in the first place, or could have. Some things are simple. Hey, the chair added something to the agenda and the board took action on it. Everyone basically knows that would be inappropriate. So why spend all that time waiting? If someone files the complaint within the 10 days from that action, then in agreement with, as you write here, the executive secretary and the chair of the commission, if they agreed to that letter of remediation.
Yeah, and this is, like I said, just to fix kind of obvious mistakes that I think everybody agrees to. Are there any questions let me ask for the committee members. I know our public have commented a lot, but do the committee members have any questions about this or any concerns? Are we all okay with this?
Okay, yep.
Okay, so Greg or Kevin or Tom, the only other people. So does anyone have a comment? Okay, if not, then we will accept that this is a part of the proposal. The last item is 104, item 3, or subparagraph 3, and that is regarding absences. And unfortunately, we have ours printed up in green, and I can't really,
What does that say?
I can't really read it.
This don't work.
I know, I apologize, but essentially, I can give you the substance of it. Essentially, what we had currently is that suspensions do not count against absences. But there is a proposal from the NCO to have the suspensions count. So if we gave, like, say, a 3-month suspension, that person would meet the requirements for being, having come up for review and being potentially kicked off the board, or removed from the board, I should probably say. And I think the sentiment was that this would give the board an opportunity to sort of review that board member's conduct and make a decision whether they want to keep the board member or not. Is that reflective of?
Yeah, it's kind of so that's how the plan currently is. It allows it. I think a change was made to alter that and not have those absences count. And so this would just be sort of a revert back.
Well, but the plan only allowed 2 months suspension. So we actually dropped that requirement. I think that's why we reviewed it, because it could be a situation where it would automatically find, that you would be put in that boat of meeting the 3 absences. So committee members, does anyone have any comments?
So this would make it such that the suspension wouldn't count toward the absences. So they could be where the board can determine that there's a vacancy.
Well, this, so we currently have it in the proposal that, yeah, it does not count against the absences. But the proposal from the NCO is that it would count against the absences. And so the board could then have to.
Or it says resulting absences shall not count as an absence as for the purpose of members attendance. So I think it's suspensions would not be counted against the members, all right?
So in the current plan,
I'm
sanctions.
talking about the green.
Yeah. Yeah,
Right.
so just to clarify, in the current plan for sanctions, 218-104 sanctions, number 4, it allows. Yeah.
Anyway, but that's.
So the thing is that, so in 218-104 sanctions, for one of the options for, say, the commission after conducting a hearing is removal of a board member from the board for the remainder of the member's term of office. Another point right above that, number 3, is suspension of a board member from the board for a period of not more than 60 calendar days. And I think that's, and I think that's what was struck. But I guess the point was that the commission themselves could have the power to, in the current iteration of the plan, just remove someone from the board term. By reverting back to the suspension process, maybe that's not a choice the commission would want to make, but that's a determination that the board may want to consider. And it's giving the board that empowerment.
Okay, well, we can't really read in there. So, but if we could just get the intent of the committee members. I mean, that's
just to clarify.
Would you be agreeing that we should have it count against their absences?
That's the current provision.
The current provision says yes.
Oh.
Yeah, for
So,
up to 60 days.
Why would we change it?
I don't know why you guys changed it.
Well, I think we changed it because we allowed more than 60 days, or we allowed the option for more than 60 days.
Yeah, right. So I mean, even if you did, so
Okay.
why would we not count it?
Okay, well, yeah, so is everybody in agreement that we should count it?
Yeah. Yep.
Okay, all the committee members, I should say. Okay, thank you, Maya. Tom, do you want to add?
Yeah, I was just gonna say, that was one of the considerations from a long ago, that regardless of whether the board would take advantage of that opportunity to remove somebody, because most of them don't. The key though is, the member, I think, understands better what the risk is, if they've engaged in certain conduct that rises to the level of actually being suspended, so.
Okay,
Well, it was a better deterrent.
If you leave it in, we take out the not, right? Take out the not, you count it. It's still up to the board to determine whether they're going to declare a vacancy or not. Because if you have more than 3 absences, they can declare a vacancy. But if they choose not to do that, then they can keep the member. So there's still that option. It's not foreclosed, right? By keeping the current language of counting it.
okay, so I hear that the committee members want to count it. So with that said, Kevin,
Chair, thank you. I'm just thinking back to the way back when. Could a complaint be filed against an entirety of a board or a subset of a board? And if so, if found to be in error, could this result in a majority of a board being suspended?
I would think the answer is yes. And I don't know about found in error. I mean, are you talking about the board does something in error and that's the basis of the complaint, or the complaint process is in error?
But if a complaint is filed against multiple board members and we get down to the bottom, now we're at sanction time, and it's the respondents, not the complainant, that's getting sanctioned. This is saying that the commission could just strike the lot of them. And then how do you deal with that? How does the remaining portion of a board decide if they want to kick off those guys because they were gone for 3, 6, or 8 months? You're not going to be able to have quorum. Then we'll come to the commission and say, hey, can you give us some extra members for a while so we can discuss this? I think there's a lot of.
Well, that would be a calculation at the time, but anyway,
Right
I
now,
would say,
I think right now the plan allows for the commission to remove.
yeah,
the
they can,
complaint process.
but also, I don't think in any circumstances there are sanctions against the non-respondent. So I don't, yeah, we wouldn't, sanction other people. Okay, do you
Yeah,
want to just follow up on that? Is that what you, because I think that's what I heard you say, and so they would have to be specifically addressed in the complaint.
if I heard you correctly, Chair, you said when a non-respondent being sanctioned. Heck yes. As a complainant, I was in receipt of a penalty for being involved in a case that was filed. And that certainly was not fun, but it happens.
Well, the complaint is a party. That's a little different. You're right. I didn't think about it that way. Yeah, I don't know really the answer to that, but I guess the complaint is a party to the action. That's different. What I was thinking of is non-parties, like other board members that are not part of the complaint process. So, okay, great. Go ahead, please.
Thank you. So there's an oath that all neighborhood board members take to uphold the laws of the state of Hawaii. The Sunshine Law has the word law in it. It is a law. I think we'd all agree here that that's a law. It's somewhat comprehensive. And if you have a board chair that's been informed not to do something, that it's a violation. So it's a formal written document, although it might not be considered a complete formal process for that review, but it's still in writing. It's from an attorney, so it's formal. And that chair and 3 board members, so just giving you the example, 3 board members violate that openly at a meeting, and they're warned, don't do it. That in itself is violating your oath, violating, the chair's violating a number of sections of the neighborhood plan where he's got
You're talking, I'm sorry, you're talking about.
I'm giving you a scenario. I'm giving you a scenario for a reason. And the reason is, and it's important because real life examples are what you should be working from.
But
Because you're never going
but what section are you addressing? Like what is the purpose of your illustration or your scenario?
Well, the example is the one I gave earlier, that a PIG, permitted interaction.
Okay.
Was already POW. They did their 3, they formed, they gave their report, and then they came back and were giving a second
What is
report.
this about the 3 absence?
Okay.
Not about the 3 absence. But it's just regarding what you were talking about that's within the commission's purview. And so it's part of this because it's embedded in what you're able to do in that portion where you have the ability to actually pull someone off of a board, but yet you don't do it. You're not actually enforcing the law of the state of Hawaii and the oath and the neighborhood plan. So I'm just bringing that up because you're talking about a section and yet you don't enforce the complaint procedures and even in this section. I've yet to see anything come of this, and I don't think I will in my lifetime. And it's relevant to this discussion because where are we going to get to a point where these issues stop and the NCO is actually stepping up? And I'll stop there, but this whole meeting, and the more I see, the more I hear, the more I realize that it's just nothing's going to change. Nothing.
Okay, thank you. So does anyone else wish to offer any other observations about all of chapter 18 besides the issues that we've already discussed? Does anyone have anything new to offer? Tom, go ahead.
Just a real focus point, and it would be a matter of clarity, just as a note for later. On page 5, in the first portion of the yellow highlighted 218-102, the end of that section 8 statement says set forth in this article. Now, what you have to really think about is.
It's supposed to be chapter. Yeah, that should be changed to chapter.
I disagree.
Okay.
From memory, anyway, I believe the information and review process is set forth in chapter 11, which are the rules and procedures of the neighborhood commission, and therefore are not part of the neighborhood plan. So article is correct in that framework, but again, it's not normally how we talk. And so in that regard, especially when you look at the next section, which specifically refers to HRS chapter 92, then I would make the reference there to, chapter 11 of this article, or simply the proper 211 whatever, the actual section number, because this title is the, as it relates to both the neighborhood commission and the neighborhood boards, is what's being referred to. So rather than just article, I'd change that to a specific reference to a section for where the information and review process is set forth. Because it is not part of the plan, which is chapters 12 through 20.
Well, I'm not following you because using the information. What do you think it's not part of the plan again? I apologize.
If you look at, I hope I got my numbers right here. If you look at chapter 11, chapter 11 is the rules and procedures for the neighborhood commission.
Right.
It is not part of the plan. It's part of the title that relates to the neighborhood commission. Then when you look at the start of chapter 12, then you have the reference that chapters 12 through 20 shall be referred to as the neighborhood plan.
Oh, does it say that?
This is one of those detailed points of the distinction between the rules and authority of the commission
Yeah.
as referred to in the charter, compared to the boards, which are then the creatures of the commission.
I see what you're saying. Yeah, I see 2-12-101 neighborhood plans 12 through. Okay, good point.
Because we kind of had it all together, and that was one of those final points of clarification if you go from Port Council to.
Okay.
So
So we
we're actually gonna have two sets of rules here, one for the commission and one in which there's overlap between the boards and the commission and neighborhood.
I wouldn't think this would be a big sticking point, but we could
No,
go
but just,
chapter 11 and
yeah,
neighborhood.
reference number would be preferred,
Right,
as compared to.
it's just clarification.
Okay.
Right.
Okay, thank you very
Get
much.
you there faster.
Thank you for that.
Thank you.
Kevin,
Thank you, Chair. I appreciate the comment from Mr. Heinrich. Is there a preferred way then to refer to portions of the document that we have that would be, for example, 211, 401, but not put the NP neighborhood plan section in front of that? Is there a preferred way that we can refer to that you may recommend, Mr. Heinrich? Title
Well,
2.
we will, we're going to go back to that because, we have to figure it out. So I don't know that we need to discuss it right now, but yeah,
We'll keep it in mind though.
yeah, we're going to do something. Thank you.
The point is to make it as easy as possible for the users.
Yeah, well, actually, I don't think the users are probably going to get the deference, but we should make it, it should be clear. Okay.
I have one quick question.
Yes.
Moving back to page 7, do we agree to take out not
We agreed to count, I don't know
about
about,
the absences?
yeah, we agreed to count the absences. I can't read it myself. So I don't know. I would say, it's just a couple of words, so I'm not exactly sure. Yeah, okay, so if that's it.
I think for what's there, the one word that comes out is not.
Okay, well, then that's, if that works, then that's what we're doing. Okay. So anyway, any last comments? Okay, so I have changed, the changes that were made is we will remove mediation and we will adjust the absence language, and apparently that's just removing the not. And those are the only adjustments that I recorded. I guess I'll see when I review the video, but I think that's it. Kevin, did I miss something? Oh, and also Article 102, I'm sorry, Section 102. Yeah, go ahead.
Yes, wherever I found that missing neighborhood that was presented just as neighbor.
Oh, yeah. I wrote that down. I thought, yeah,
Okay.
that's just like a little grammatical thing, so I hope the committee's not.
Yeah.
That's because obviously it's neighborhood, but yeah, thank you, Kevin, for pointing that out.
And deleted mediation.
I said that, deleted. Sorry, okay. Yeah, no worries. Okay, so with that said, are we ready to take a vote on this and present it to the commission for their review? My understanding is, I don't know what the commission would want to do, and you'd have a lot more knowledge than I would as far as, would they just look at it and say, okay, this looks good, we're gonna send it to corporate counsel, or do we give them a month or give them more time, or what would be your?
I think you have to explain the idea of separating the complaint process out, because, what I've seen in the past is that it's a whole package shipped to council. It's not just one section, so that would be something new for
Right.
separate the complaints process. So, to me, that's what will be up for discussion
But,
with the commission.
did we get that on the agenda, or I guess we have our report?
Yeah, for the report.
Yeah, I just don't know if, I mean, can we ask the commission, like, I mean, I would think people who haven't seen it would really wanna
I would think they would. want
know,
to-
because it's a complex document, so I don't know that the commission would be prepared. But I guess the final thing is, are we ready to report this out of committee to the commission? Does everybody feel comfortable with the changes? And I know everybody who is here tonight is a commissioner, so you will see the changes.
Yeah, you gotta-
Very minor.
You have to present the changes, because if you do it at the next meeting, then they'll have it.
Yeah.
And possibly the following meeting, you're gonna have a whole bunch of new commissioners, so, it's an
Right.
education process. Kind of all over again, so it's better to have something in writing for them to take a look at. And then you
Well, I
can
just meant the
explain.
changes tonight, and that'll be
Yeah.
incorporated. So, yeah, and then we'll have I guess, put together a big document of, well, I don't know if I can do that by next week. But,
You said you gotta do it in Ramsey.
the way it was done in the past is there is like a table outline. I pulled it out so it would give like the old provision, and then it would give the new provision. So I don't know, and Tom, you tell me, is that the way that you think it would be? But doesn't it go to corporate counsel first?
But I appreciate especially the table idea there. At my great risk, my schedule at the moment, is I can definitely make time available, to help lay some of this out.
That'd be fantastic.
Yeah, whatever.
We would greatly appreciate that.
Next Monday is out, but other than that, fortunately, my schedule is very flexible right now, and
Thank
I'd
you.
love to do it. Secondly, I think it is most helpful to do it in a table format, not Ramsire format at this particular moment, okay? Because that's just more confusion. It is a lot easier, as Richard said, it's going to be several steps of education here. So the cleaner you can just be able to kind of go, well, that's almost the same thing. This is different, but the table really is a matter, in my mind, of current, proposed, and a couple of comments or whatever as to what is the different, so this, so
What
you have.
format has to, when it goes to public hearing, what format do we have to take? Does it go in Ramsar format or some other format that you're talking about?
At that time, I'm more comfortable saying it would be Ramsar.
Between
But-
the if
But
plan
a
and.
table being available as a matter of public education or
Yeah.
whatever is very useful.
Well-
But when you get to that step, because when you've got to do the public notice
Yeah.
for the hearing and stuff, then the remember this clearly now, the Ramsar must be available for review. Okay, because later, when it's at the point of being proposed or being announced as having been adopted or whatever, then if this is one of those that has to go in the paper, then what goes in the paper is the Ramsar version.
And then they do a clean copy at the end.
Correct.
Okay, let me go back to the basic point. Are we ready to make this, to pull this out of committee and to refer it to the whole commission? If everybody's in agreement, is there a motion to that effect?
I'll make a motion.
So Larry, moved. Do I hear a second?
Second.
Okay, Lloyd,
Did we finish all the things? Did we leave some things hanging still? There's some mail.
We do, but we could, bring
We
that
didn't-
up with
we
the
didn't
commission. to-
resolve that.
Yeah.
That's still hanging.
I think that was, the mail was, we were gonna look at the language.
There's also
because it
still
was
another
not-
couple public reviews and stuff too. So there's like,
Well, this is just reviewing to the commission, so this is not the end of the process. But I mean, do you feel like the committee needs to
So I'm
come
ready
back?
to vote on it.
Yeah, so so that's what this is. It's not the end of the review process because other commissioners might pull stuff out and say, this is not clear, or I don't like this, and whatever. So is there any other discussion? So all those in favor of the motion to report the proposal with the modifications we talked about this evening, yeah, leaving a little up in the air the language of the email, but we're incorporating something. With that said, to report the proposal out of the committee to the commission. All those in favor say aye. All those opposed say no. Are there any abstentions? So it is unanimous that we report out.
Do you need something on the agenda before they finalize it? Besides just a report?
It would be good to say kind of, I have a presentation on
Yeah.
it. But I don't know that's absolutely, it's up to you if it's necessary.
If you want to put something on, then maybe we should.
Maybe we
Maybe
should
as
go-
a sub item on their report.
Yeah, if we could do a presentation, I could do the flow chart and then, that might be an easy graphical way.
Put
for
it
us
under
to-
the report and then, we're presenting this, yeah, that makes sense.
So Kevin, did you want to add something?
Chair, thank you. I'm just thinking if this is going to happen so acutely, is there going to be an effort to broadcast this to neighborhood board members who have a vested interest as well in learning about this and hearing your presentation as early as next week, if I'm understanding correctly? Or should this be deferred by a month to allow a full cycle of all the boards to happen, an announcement by diligent chair, say, hey, I think this is important. I think you should all come to the neighborhood commission meeting.
I don't really know the answer to that. That's a good, yeah, I understand. I understand that it may affect a lot of people. This is just a report to the commission initially. It is unlikely the commission, I think it's almost, without a doubt, the commission will not take the final version and report it out. There may be it looks like there will be a change, a little change to the composition of the commission in the near future. So I see there's going to be a lot need to educate more. So there will be additional opportunities. It will not just be next month and we're going to rubber stamp it and pass it out to corporate counsel. So there will comfortably be a time to review. As far as getting it out to the board members, I don't know. I don't know if Lloyd wants to do that or.
Yeah, but we're not ready to send something out today, so.
Okay.
Yeah.
Yeah. I mean, I think, but if people are interested, I don't know. So we'll leave that up to the NCO. We're still a little early. I mean, this is obviously a big step in the process is to get it out of committee, but we're still early in the process. It still has to go to corporate counsel, and then we got to do all the editing and create tables and the documents. So there's time. Okay, so that answer your question? I'm sorry. Okay, so with that, I would say, I don't think the committee needs to meet again. We will, in the near future, we're going to see how this comes out with the commission. When the commission digests this and makes some decisions, then I can post it, and we may have to redo the chair too, so I don't know. We'll play that by ear. So it'll be, the next meeting will be to be determined, but it will almost certainly probably not be next month. Just so everybody knows. Is there any other business or Kevin?
Chair, thank you. I just want to apologize to the committee for my issues earlier with not being able to find the folder. I tried a different browser and found the folders. It was a local error. I apologize. Thank you.
I would hate to ask what browser you were using, but okay.
I'll tell you later.
Edge. Okay. All right. Well, with that said, are there any other announcements? Our next Monday will be our neighborhood commission. We will discuss this issue if you're interested. Any other further announcements? Hearing none, I'll conclude the meeting. Thank you, everybody, very much.